Okay, good morning, everyone. I'm Judge Lambert. Welcome to another oral argument session of the 5th District Court of Appeal by Zoom. We have two cases today. We are being, let me keep everybody on notice that we are being streamed live over YouTube. So keep that in mind when you make any comments to the court. Also, if you have an electronic device or phone or what have you, please put that out either off or in the silent mode so it does not distract either the court or your opposing counsel when you're making your argument. On the panel today with us is I'm presiding, and Judge Edwards is here, and we are also pleased to have as an associate judge Brian Duckworth. Judge Duckworth is a county court judge from Orange County, first time sitting with us, so we're pleased to have him. He sat with us on Monday, and so he's back again for a repeat performance today.
Thank you.
First case, let me say to the judges, what we're going to do is we'll just have one conference after the second case, so we won't have any conference in the interim, and I'll arrange that after we're done with the second case. First case, though, is Case 20-2564, Daniel Lucas Wilkinson versus the state of Florida. Each side has 20 minutes. You can see the clock up it's in my upper left-hand corner. I don't know where it is on your screen, but what we will do is we'll set a 5-minute default time for the appellant, if that's the amount of time you would like to use for rebuttal. If you want a different amount of time, let me know. The marshal who's keeping track of the clock will then adjust the clock accordingly, and there will be a little light that starts flashing when you get into your rebuttal time. Obviously, you can continue on past that if you choose, or you can stop before your rebuttal time. It's up to you. That being said, I think we're ready to proceed. So, counsel for the appellant, Mr. Wilkinson, you ready? Go ahead whenever you're ready, sir.
Good morning, and may it please the court. This is Jesse Wilkinson. I'm appearing on behalf of the appellant, Daniel Lucas Wilkinson. We would like to reserve 5 minutes for rebuttal for the default time.
That's fine.
Unless the court has specific questions regarding our other arguments raised in appeal, I'm going to focus on issue 1 or ground 2 of the post-conviction motion, which relates to...
I actually do have some questions. I'm looking at... maybe I'll go in reverse order if that's right. Ground sure. 5, that's before us. Failure to, what was pled was a failure to present video evidence from Mojito's nightclub. That does not seem to be what was briefed. So is that a kind of a waiver, unpreserved?
So, Your Honor, we contend that it's not for several reasons. For one, the what was pled was generally the failure to present or preserve any video evidence. And that included video evidence of his time at the bar.
That's not what ground 5 says in your motion. And I think you prepared, and I'm looking right at it. So
the other aspect is once we got to the hearing and it came out, his counsel, Mr. Taylor, testified that he was not able to find, or he tried to search for the Mojito's video footage and it wasn't preserved. And so at that point, he also testified that he did have the convenience store video that was preserved, but he chose for some reason not to present it to the jury, even though it had a timestamp that would have exonerated Mr. Wilkinson if correct. And so that's what was argued and briefed substantially in our post-hearing memorandum, and it's also the issue that the court ruled on when it entered its written order.
Well, it ruled the Mojitos. It basically said there was no video to obtain. The testimony, the 30-day loop, and it was basically erased on a 30-day loop, and your guy didn't get arrested for 6 years later. And part of this permeates, I guess, my questions on almost each one of the accounts that you had at your hearing. I mean, you raise these things, you have an evidentiary hearing for all the grounds, and it's your burden to prove, your client's burden to prove. I mean, it seems to me you have to present evidence at the hearing that says, you know what, here's the Mojito evidence. Here, one other thing about the date or the timestamp, if he would have brought this up, Mr. Taylor, I believe the lawyer's name was, this would have been different. But I mean, you make the allegations, your client kind of testifies generically about all this, and somehow that has met the burden of proof under Strickland, which I find utterly lacking. I mean, it seems to me you have to put the evidence on that says, you know what, we got this expert that says, let's go to your other ground, the timestamp. I mean, we don't know that there would be evidence that says, oh, by the way, the timestamp was correct and you had a good alibi because look at the picture. I mean, that's what you're going to have you're going to have to convince me somehow that there wasn't just a complete lack of proof at the 3850 hearing.
So, and I just want to clarify something. We're not appealing the court's ruling on the Mojitos bar footage grounds. I think the testimony
that was what was raised in the motion.
Correct.
After the fact, you find a post-hearing memorandum, which is outside the 2-year time frame of the rule. I don't think the issues were tried by consent. That's certainly not been argued here. So I know you want to talk about the June 1 phone call, but I want to clear up all the other stuff. I mean, for example, the knife. Okay, I'm somewhat lost why your client sees the knife. There was nothing that prevented him from saying at the time, I'm not taking the plea because that's Mr. Brinkley's knife, and I'm willing to testify to that. There's no proof that it's Brinkley's knife. I'm not even sure why the knife comes into evidence listening to the ME's testimony, but that would kind of militate against your position or your client's position that, oh, by the way, if I'd only known about the knife, this would have been significant, when it doesn't seem to be something that's placed there. And it seemed like your client even testified at the evidence you're hearing that Mr. Brinkley wasn't at the apartment complex on the night of the murder.
So,
I mean, so what am I missing here?
So specifically with the knife, the argument is that Mr. Wilkinson could have tied it to Mr. Brinkley, who was not subpoenaed for trial. There was no evidence or there were no witnesses that were subpoenaed for trial who could have corroborated Mr. Wilkinson's claim that the knife belonged to Mr. Brinkley, even though he was known to carry that variant of knife. And combine that with the circumstances under which the knife was found. It was in a pond adjoining the apartment complex where Mr. Richardson was murdered. And then the night after the murder, Mr. Brinkley broke into his own car, fled the state with his girlfriend to Arkansas. And so the basis of that claim is not so much what was presented at trial or wasn't, because this defense never had an opportunity to put on its case. The claim on that appeal is that there was a failure to investigate and a failure to prepare and run out that theory of defense because Mr. Wilkinson's trial counsel didn't show him the knife prior to trial.
Oh, okay. I mean, I get what you're saying. I'm not sure that answers what my view is that you have an evidentiary hearing, 3.850 evidentiary hearing. It would seem to me what would be compelling to me as a trial judge or post-conviction judge or appellate judge is, oh, by the way, that is the other guy's knife. I mean, your client believes it's the other guy's knife. There's nothing preventing your client from getting up there and saying, I know this guy. I recognize that knife. That's his knife. If that's what the state's saying, the murder weapon, I never had it. Guess what? I didn't do it. I mean, I know your client has no burden of proof in criminal cases. I was a felony judge for years and years. I get all that. But I mean, it's his time at the time of the 3850 to talk about it. And that just seemed like that evidence was lacking.
And at the 3850 hearing, I believe the evidence that was presented was that he did say at the hearing that he recognized the knife and it belonged to Mr. Brinkley. To your point that he could have said that during the criminal trial, two issues with that. It would have been uncorroborated by anything but his own testimony. And two, that he would have obviously waived his Fifth Amendment rights in order to do that and open himself up to cross-examination. So, the failure to present that evidence and allow them to investigate the defense and to present it in a way outside of Mr. Wilkinson's testimony is the basis for that ineffective assistance of counsel claim. It's more of the conduct that happened before trial than what Mr. Wilkinson was shown at trial when he realized the knife belonged to Mr. Brinkley. unless the court has any further questions, I would like to spend a little bit of time talking about the first ground, which is relates to the June 1, 2016 recording. The statement at issue in that claim, as you're likely aware, is that Mr. Wilkinson said that if anything came out and when they played Miss Wells, the mother of his child's grand jury testimony that was previously given, she should go.
Let me ask this, and I know I sound like I'm nitpicking, but that ground in your motion basically says trial counsel is ineffective for failing to show him a recording of the alleged Wilkinson's alleged acts of witness tampering, which was this June 1 phone call. That doesn't seem to be the issue on appeal.
So the ground is titled.
Am I wrong on that, or is that? I mean, I get it that's the first lead in ground 2, and then you talk about the recording was not sufficient to support an initial charge of witness tampering. I understand that, and you're going to talk about that, I assume. But I'm not trying to overly compartmentalize this, but that seems to be what you're saying, and then it doesn't seem to be what's being argued. That, oh, by the way, Mr. Wilkinson didn't get to hear the recording, and that's ineffective. I mean, you seem to be arguing here. The other thing is the lawyer didn't listen to it. The main lawyer didn't listen to it, which wasn't raised in the motion. Correct me if I'm wrong. I mean, I'm trying to get past a lot of these procedural things.
So, the motion, the title of that ground is relates to showing him the video and the failures regarding that. But in briefing that ground on the in the post-conviction motion itself, not the post-hearing memorandum, we did lay out that Mr. Wilkinson wasn't offered adequate advices, wasn't informed of the defenses that he brought out. In fact, that issue was raised in post-hearing memoranda that we had departed from what we said in the motion, and we filed a reply on that, which is in the record, that quotes the portions that parallel what we argued on this appeal and also in our post-hearing memorandum. So it really the only thing that, the title could have had more words in it, but the supporting facts and legal argument within the motion for post-conviction encompasses both the failure to show him the video and also the failure to listen to it and provide adequate advice regarding the tenability or viability of these witness tampering charges. So specifically, we said, had Mr. Wilkinson's trial counsel shown him the recording or given him adequate legal advice as to the consequences of such reporting would have had, Mr. Wilkinson would not have entered a no contest plea. And that's
on. We're talking about a phone call that he had the night before, so it's not like we're asking about something that happened 3 years ago.
Right. And so if your point is that Mr. Wilkinson could have remembered the conversation and known at the time that wasn't witness tampering, that's problematic for 2 reasons. The first being that Mr. Wilkinson and Ms. Wells contact each other on a daily basis. Per his own testimony, he said that, sometimes they had a volatile relationship. Sometimes they argued on these calls. So to expect Mr. Wilkinson to remember every word he said during a 15-20-minute conversation the night before in the middle of a homicide trial, his homicide trial, and then, scrutinize every word with eidetic memory and say, could that be construed as tampering? That's not reasonable to expect someone to do that. The second reason,
was going to testify the next day, right?
Miss Wells was?
Yeah.
So she would have testified at some point in the state's case, and probably pretty soon because they were in day 2 of trial in the state's case. Right. But the more obvious thing is Mr. Wilkinson's not a lawyer. He doesn't know what the definition of witness tampering is. In fact, during the post-conviction hearing, he even said to his attorney, if there's something on there that's witness tampering, I don't know, I'm ignorant of the law. Let's deal with that. But I don't want to plead guilty to these murder charges because he, throughout the entire proceeding, maintained his innocence, that he didn't do it. And he didn't want, these other things to make him plead guilty to a crime he didn't commit. So in regard to the aspect of had he seen the video, he would have had a better footing and could have asked his lawyers the relevant questions as to, is that really witness tampering? And even if he had, I think the failure here is threefold, really. 1, he didn't show Mr. Wilkinson the recording. 2, he didn't listen to it. And 3, the face of the recording itself didn't contain evidence of witness tampering. There's specific types of statements that you need to have under Florida law to constitute witness tampering, the relevant ones here being a threat, intimidation, or harassment. And I'm probably not going to have enough time to explain all of those.
Here's what I'll do. I'll give you each side additional 5 minutes.
Okay. So first, going into threat, we've cited, there's a case out of the Fourth District Court of Appeals, Benengus Membran, that addresses this. And specifically what was argued in that case was that the state tried to say any type of manipulation of witness testimony could be a threat or intimidation under that statute. And the court looked at it and they compared the Florida definition to the federal definition of witness tampering. And the federal definition of witness tampering uses the phrase corruptly persuading. So in other words, under federal law, if I take any kind of corrupt action to persuade you to testify in a certain way at a trial, then I could be guilty of witness tampering. What the court in Benengus Membran said is that that isn't the case in Florida law. The Florida legislature chose these very specific words. And so any attempt at manipulation is not going to be considered a threat. And in fact, other cases that have looked at the definition of the word threat in other statutes have found the definition that Poivy state cited was an expression of intention to inflict evil, injury, or damage. What Mr. Wilkinson was, quote, threatening to do was break up with Miss Wells or cease contact with Miss Wells. And, that doesn't meet any of those definitions. There's no damage there. He's well within his rights to break up with her. In fact, it would be expected that their relationship would end if she went on the stand or if she went before the grand jury and accused him of murder or accused him of confessing to murder. So I'm not really sure how that would have been construed as any new information to her. Furthermore, there's kind of woven throughout these definitions a sense that a threat should be an infliction of physical harm or some kind of damage, which this certainly was not. And finally, Benengus Membran held that tugging at the heartstrings, which is, saying, oh, if you do this, it's going to be problematic. In that case, the defendant was saying you're going to lose custody of your children if all this comes out. The court said that was just tugging at the heartstrings. That was not one of the three definitions of threat or intimidation under the witness tampering statute. And then as it pertains to harassment, it's worth noting that harassment has a different definition than threat in terms of what the person is trying to get the witness to do. Whereas a threat or intimidation, it's unlawful to try to get them to withhold testimony or testify untruthfully. Neither of those phrases appear in the definition for harassment. Specifically, the one that harassment keys off of says attending or testifying in official proceeding, meaning harassment is geared more towards showing up to testify at all, whereas a threat by its plain language can be prosecuted if you want them to testify, but want them to testify untruthfully or withhold testimony during their time in the proceeding. So clearly, if you look at that conversation, Mr. Wilkinson was not trying to discourage Ms. Wells from attending his trial. In fact, he was actively encouraging her to do so, saying, you need to make sure you tell the jury this, you need to make sure you tell the jury that. So this doesn't meet the definition of harassment just on its face. Furthermore, courts have held that the common plain meaning of the word harassment is, involves some element of unwelcome contact. And once again, the record here shows that that Miss Wells welcomed the communication. Like I said, they talked every day. She accepted the collect call. When she talked to Mr. Wilkinson, she didn't say, don't call me. Mr. Wilkinson told her that he was going to call her back. She said, okay. She was helping him arrange witnesses, helping arrange to get him a new suit for the trial. So this was not a situation like the Pickett case that the state cites in their brief, where the defendant was, harassing and calling and using subterfuge to conceal his identity to get to talk to this witness. These were two people who were in a consensual relationship that talked consensually while Mr. Wilkinson was incarcerated. And the final issue here is the state has been relying a lot on the emails that Mr. Wilkinson sent in March and April of 2016. But those communications were already charged to Mr. Wilkinson as witness tampering. He was aware of the charges in June of 2016, and he chose to go to trial, and he chose to reject the state's prior plea offer. So really the communication at issue here is not the prior ones he's had, because he's already facing charges for those, but the June 1, 2016, because that was what changed his mind to between going to trial and entering the plea, which he ultimately did. And the final issue that kind of encompasses all definitions of witness tampering is that witness tampering contemplates a statement that influences a witness's future testimony. In other words, I'm going to threaten you or harass you to not show up for court or testify in my favor or not testify against me. But it's very clear if you read the context of that phone call that Mr. Wilkinson was talking about her prior grand jury testimony. At that point, there was nothing Ms. Willis could do to change that. It was already set in stone. So this can't be seen as an attempt to influence her testimony because she'd already given it. And I see that I'm closing in on my rebuttal time. So unless the court has further questions, I'll reserve the rest.
You understand you now have 650 left.
Oh, I have 650. Okay, then I'll I can keep going then.
It's up to you.
So that's the one failure with the tape, is that just on its face, this tape could not be charged as witness tampering. And if it could be charged, it was a very weak case that had many defenses that Mr. Wilkinson could have asserted. So,
but wasn't that the issue to the lawyer saying, I don't think either lawyer suggested to Mr. Wilkinson that, you've really done it now. They've got a strong case. They said, here's the scenario. They're threatening to charge you with another crime. It would be another life felony. So you'd be looking at 3 lives if they, and you could potentially get 10 years by taking this plea today. You're looking at now potentially 3 life sentences you're facing. Now, whether the state dropped it or there was a motion down the road, and the time frame was very compressed. The state made they're in the middle of trial, and the state said, here it is, Fisher cut bait. That's for Judge Edwards, who's a big fisherman. Fisher cut bait. And, so they basically, it seemed like they were being cautious, saying, look, it's not good, but it's not a slam dunk. It's not anything. So what that then reaches the Strickland level, your client, one of the things we look at is, the potential sentence he was facing versus, I know what he was ultimately received, but he could have gotten 10, I guess. The state made that offer and the judge was, that. And I understand, like the lawyer was damned if he didn't. If the lawyer said, don't worry about it, there's nothing to this, you got nothing to worry about, and then your guy goes to trial and gets found guilty and gets life, then we'd be having the same conversation saying, why didn't he recommend that I take this? I would guess. Well, maybe not with you, because that'd be inconsistent with your position. But.
So, and what Strickland requires and the fault and advice that happened here is that he didn't listen to the reporting, so he couldn't comment on the defensibility of the charges. And in recommending advice to plea, whichever way that recommendation ultimately swayed, he had to counsel Mr. Wilkinson on the viability of those charges and the potential defenses there too. And his attorney was in no position to do that at the time.
Are you saying that when you have a team of lawyers, every lawyer on the team has to evaluate every scrap of evidence that there is, or can you delegate to your co-counsel to listen to that, especially under the compressed time frame?
No, we're not contending that every attorney needed to render an opinion. But in this specific case, Mr. Waldrop testified that he didn't give Mr. Wilkinson any advice. And all he determined was that the state could have prosecuted him for witness tampering, but whether or not it held its weight in court, I did not render an opinion. And that's what Mr. Waldrop said. So it wasn't necessarily an issue of that Mr. Taylor had to view the tape, but the attorney who was giving the advice and coming to the legal conclusion had to have some familiarity with the evidence in order to support that recommendation.
Okay, you got 3:30 left if you want to keep
All right.
that.
I think I'll pass it over to the state.
Okay. Good. All right, Mr. Pallas, before you start, let me talk to the marshal. When Mr. Wilkinson gets back up, he's going to have 3:30 left on rebuttal. We're giving each side 25. So our marshal, you can change that to 25 instead of the 20 right now on the clock. That would make it. I guess we're all grown up and understand math. We could probably figure it out, but that just makes it a little easier. All right, Mr.
I appreciate
Pallas,
it.
clock's ready. You got 25 minutes if you want to use all that time.
Thank you, Your Honor. It's a little early for me to be doing math, so I appreciate it.
Okay.
May it please the court. My name is Richard Pallas. I represent the state. Because the defendant did not meet his burden at the evidentiary hearing, the trial court correctly denied this motion under Rule 3850 for alleging ineffective assistance of counsel. All of these claims are simply buyer's remorse dressed
But
up under.
don't we have a scenario though that the record seems to suggest that at the start of the trial, Mr. Wilkinson was offered 10 to 30 based on the charges he was going to trial with, plus the more recently filed tampering and perjury charges. He rejected that. And then what changed the tune, for lack of it, was this threatened second tampering charge. Now, I suspect the appellate counsel and the trial counsel had hoped that Mr. Wilkinson had not made this June 1 conversation, but that seemed to be what shifted the paradigm here. And didn't counsel then have some obligation to say, okay, let's think this through. Is this really a viable thing, or is this just the state, kind of blowing smoke? I don't mean blowing smoke. I mean, making this thing that really won't be something that could stick. I mean, even Mr. Wilkinson at his evidentiary hearing kind of said, this kind of forced his hand with this cowardly act by the state. He didn't really complain about his defense counsel at that time. He obviously is now, but that's his right to do that. But go ahead.
Yes, Your Honor. I believe it's important to look at the circumstances of this plea. Of course, the defendant, there is plenty of evidence that he had rejected prior plea deals of similar time for only these 2 life felonies that he was currently charged with. But besides all of that, I think it's very important that this charge isn't just another life sentence that he's potentially looking at, but this evidence is going to come into trial. At the opening statements, the state had already discussed that the defendant had spoken to Ms. Wells, trying to influence her testimony. That consciousness of guilt or indicia of guilt evidence is going to end up coming into this trial. Now, in the middle of trial, after the state has put on its law enforcement witnesses, the defendant is again potentially trying to influence a witness who Mr. Taylor testified to as a loose cannon witness. Clearly, this is going to change how this trial is going. None of the state's witnesses that so far had testimony of the defendant's admissions had testified yet. There were at least 5 to 6 from what I could count during both the defendant's sentencing hearing, as well as Ms. Wells, of course. I think that keeping all that in mind, and the fact that we may indeed have this evidence coming in, the defense attorney had to know it would almost be an Alcorn claim if he did not say it might be better that we give you a chance to see sunlight outside of the Department of Corrections at this point.
Let me make sure I understood what you were just saying. You're saying that the state had 5 or 6 witnesses they were bringing to trial that would say that Mr. Wilkinson, had confessed? Is that what you're saying?
Yes, Your Honor. If I remember correctly, with the sentencing transcript, during the defendant's testimony, ASA Miller, now Judge Miller, asked the defendant, after he made his statement saying that this was a cowardly act by the state to charge him and force his hand into this, the assistant state attorney mentioned the names Ashton White, John Langley, Sarah McComb, or Sarah Sullivan. I'm not sure if that was a changed name, as well as Jessica Osmond. And whether Sarah Sullivan and Sarah McComb are the same person, there's still Ms. Wells that, of course, we have testimony ad nauseum about her regarding this tampering charge. But going back into this, if we look at just the Grosvenor, Hilvey, Lockhart factors regarding the totality of the circumstances here, yes, on the defense side, we can say the defendant rejected pleas in the first place, but now we know that the tenor of this trial is going to change. It's not going to look as good for the defense. The state's going to have a slightly stronger case, and the defense is looking at the potential of 3 life felonies. Even if this tampering charge doesn't stick, he's still looking at 2. And there was no evidence adduced at this entire evidentiary hearing that shows that the defendant is going to be successful on his first tampering charge from the March correspondence. So if he is successful in withdrawing his plea, he's still looking at life. And case law says even if you beat your underlying felony, you are not going to get an adjusted maximum sentence for the tampering or harassment charges. And also with those Grosvenor factors, the plea colloquy itself, there was none of this talk of the defendant stating that the state's forcing his hand or anything. The Judge Wolf, I believe, Judge Wolf had asked him, did you read this entire plea form? Is this your initials on every page? Every one of those pages talks about the voluntariness of the plea and that he's waiving his jury trial, cross-examining his witnesses, all of his constitutional rights. After all of this with the plea colloquy, that was done on June 2nd of 2016, and he wasn't sentenced until August 12th. He had over 60 days to change his mind. He did not. And Mr. Taylor actually listened to this audio in case there was any reason to go back on this plea. We have no motion to withdraw plea, which would have been under the lesser good cause standard. We have no motion to withdraw plea after he received a sentence that he certainly did not like after the sentencing hearing itself. I don't believe that even if there is some way to say that there is deficient performance at all, none of this prejudices the defendant under the Hill v. Lockhart Grosvenor factors, Your Honor.
Counsel, did defense counsel have an obligation to advise him on the strength of these potential charges that the state was threatening to bring? Because I think the evidence or the testimony was fairly clear that they just said they could bring these charges, and we don't really know whether they can stick or not. I mean, what obligation is there to say this could be a strong case? It's nothing to worry about. I mean, where does that all fall?
Well, yes, Your Honor. There is, of course, an obligation to talk about these charges, but the trial counsel does not have to write a treatise for the defendant. Here, it was enough for them to say they can definitely charge, you may or may not be convicted. I mean, again, showing the defendant this audio, as stated by the defense earlier, the defendant is not an attorney. He's not going, you can say, look, here are the factors, here's every element to tampering and harassment, of which there are numerous ways to charge these crimes. And the defendant is magically going to have an understanding of this. That's not going to happen here. Again, we were on a time-constrained situation. Mr. Taylor was more than allowed to delegate this task to Mr. Waldrop, who came in, gave his opinion, and whether or not these convictions would be sustained, this was the right call to tell him you may or may not be convicted. But right now, they were there for the murder charge. At this time, it was a capital felony. This was downgraded to a lesser manslaughter instead. I believe that what Mr. Taylor had done was more than sufficient under what's required under Strickland, especially in this circumstance where normally we're looking at Hill v. Lockhart, where there never was a trial, or Strickland, where we went from jury selection to verdict. In this case, things were going well at this point, but the worst of the trial had not come in, as Mr. Taylor testified. I believe that by saying, if anything, the baseball metaphor that he gave the defendant was more than sufficient in how to go over these charges and saying, can you run the table and hit 5 home runs?
Well, he's talking about 3 home runs, and the guy who was pitching wasn't a pitcher. So
That's
Barry Bonds was the hitter. I don't remember who the guy was pitching. It was another hitter. So
Chipper Jones, Your Honor.
Chipper
So,
Jones, right.
perhaps he was looking more at home run derby, but that's beyond me at this moment. But nonetheless, whether we have a star pitcher in this scenario, those tampering charges, just to get into the merits of them a little bit, there's so many ways that they can be charged. The Benegas Membron case is strictly set to the intimidation factor, which intimidation is only one of many ways to charge the actual charge of tampering with a witness. It's intimidation or physical force. you have threats of another person or attempts to do so, you engage in misleading conduct or offer pecuniary benefit. There's perfectly arguments in order to say that this was a threat or that this is distinguishable from Venegas Membran, in that intimidation actually does settle in here and this wasn't tugging at the heartstrings. I know that Pickett, the case that the state cited to in its brief from the 4th District Court of Appeal, that case has far more contact here. But importantly, Venegas Membran talks about how other people are going to take away the victim's mother's children. And that opinion is specific in stating that it's discounting threats because of the fact that it's not the defendant threatening to take away the victim's mother's children, a witness in this case, that there will be other people, and that amounted to a tugging at the heartstrings. In our case, this is the defendant telling multiple times, I don't want to hear it. I'm not here to argue. Him clearly raising his voice while the audio is not in the court record. The statements that he makes, such as I'm trying not to yell, show that this man is clearly not speaking in a kind tone to Ms. Wells. And that's a question for the jury, as under Pickett. And the context that comes from those prior calls, while he's already being charged for them, whether this ends up being an amended information in the case stemming from the March 13th correspondence or not, it becomes another separate case. These are going to be considered together, and there's no way to leave this context out as to why the defendant is doing this, because this is the defendant's trying to influence this witness to testify his way. And to touch upon harassment real quick, the defense does not touch upon the full statute under subsection 3. Subsection 3A talks about that you're hindering, delaying, preventing, or dissuading anyone from attending or testifying at all. Of course, he wanted her to testify. He wanted her to testify his way. And that's under subsection D, which talks about that you're hindering someone from assisting in a criminal prosecution. Clearly telling someone to play ball his way is him trying to do this exact type of harassment. And here it's very bare semantics regarding the difference between being charged as harassment and tampering, because tampering, this would be a life felony. In harassment, it would be a first-degree felony punishable by life. Unless there are no other questions, I will rely on the state's brief, and I ask that you affirm. Thank you, Your Honors.
We're good? All right. All right. Thank you, counsel. All right, Mr. Wilkinson, I think you have more than 141. Give him 341. We'll call it even. All right, there you go. 341.
Sounds good. I just wanted to touch on a couple things that the state said in its argument, specifically first regarding prejudice. The state brought up the fact that the some of the witness tampering statements could have been used as 404 evidence in the homicide trial, or that, you know, that they were only just beginning the trial and things could have gotten worse. But I want to point out that Mr. Wilkinson already knew about the April-March conversations and the possibility, presumably he knew about the possibility they could be introduced to his homicide trial. He had been informed of those, and he chose adamantly that he wanted to be tried for his homicide conviction. So regardless of the advisability of it, it's ultimately the defendant's right to choose whether to accept a plea or go to trial. And he had exercised that right to go to trial. In terms of the impact that these would have on his homicide trial, he had already factored in that some of the very similar and in fact much worse statements were coming in, and made the decision that he wanted to go, he wanted to have his day in court. Furthermore, even if he had been convicted of the March-April witness tampering charges, he still could have earned an acquittal on the homicide trial if he proceeded to trial. The evidence was weak. I understand the state brought out several witnesses that would have testified that he made this confession or purported confession, but many of these witnesses were trading their testimony for lighter sentences. Ms. Wells, who seemed to be the state's strongest witness, was described as a volatile witness who could have gone either way. And in fact, in that conversation with the state, there's statements that she made that the state was pressuring her, that it was harassing her. So if the tape did come in, there were many things in that tape that could have supported Mr. Wilkinson's theory of the case at the homicide trial. Furthermore, the evidence itself in the case was not particularly strong. It was a very old murder. There was no physical evidence linking Mr. Wilkinson to the victim. And the victim lived this on-the-edge lifestyle where he would pretend to be a woman and invite heterosexual men into his home and trick them. So there was ample reasonable doubt in the homicide trial. And Mr. Wilkinson, factoring that in, wanted to have his day in court, only changed his mind because of this recording that he wasn't advised the contents of, and his attorney's recommendation that he should enter a plea based on merely the fact that it could be charged. Speaking to the baseball metaphor that was discussed in arguments and that Mr. Wilkinson's trial counsel used, I understand the idea that hitting 3 home runs might seem like a tall order, but I think it also depends on who's pitching. If we're talking about a case where it's likely to get thrown out at a motion to dismiss, or that it's not very strong, Mr. Wilkinson should be apprised of the chances of hitting each of those runs. Having someone be charged with multiple crimes is not uncommon in the criminal context, and it doesn't change a defendant's right to be advised of the state's case on each of those charges and the probability of success that the state would have at trial if he proceeded to one for each of those charges. And for that reason, we believe that the circuit court's order denying post-conviction relief should be reversed. Oh, Judge, I believe you're on mute.
Judge Lambert, you're muted.
All right. Thank you, Mr. Wilkinson. I just wanted to comment. We all thought your briefs were very well written in this case. So,
Thank you.
all right, then we will stand adjourned and take this matter up under advisement. And again, judges, we'll just hold off and I'll call you after the 10 o'clock oral argument.
Okay.
All right.
Thank
Thank
you.
you, Your
Good
Honors.
morning.
Mhm.